Hey everyone, and welcome back to my channel, Chat South Africa with Pammy T. Now, my name is Pammy T, and you are always welcome to stop by. So, today, many South Africans are celebrating the fact that the VAT increase that we were initially told would be taking place on the 1st of May increased by 0.5%, which we had initially been told was supposed to be 2%. So it was moved from being a potential 2% to being 0.5%, which was supposed to take place from May. So the Democratic Alliance, as well as the EFF, had taken this matter, or this decision rather, to High Court. Let's take a listen as to how things went with this decision at the High Court.
So to begin with the Section 7.4, as the court is aware, the rate is set in Section 7.1. There are other tax statutes where the rate is not set in legislation. It's set in schedules or it's set in regulations. That is set in the Act itself. So how does Section 7.4 operate? The first point, which is one that Justice Savage made, is that it can only be done at the budget announcement. So that's the trigger for the minister's power. And the minister makes much of this, and he says, oh, this shows what a public announcement it is. I must do it in Parliament and everybody will know about it. And that's true. But the other reality about it is that there will be no public process before the announcement. No participation, no draft put out for public comment. The minister announces it and then it comes into effect on the day he says. It could be the next day. And so this is actually even worse in a sense than what happened in New Africa and Casino Association. In both of those cases, there was public participation about the regulations before they were enacted, and those regulations changed the tax rates and were then challenged. But at least there was a regulatory process with public participation. Here, everything happens behind closed doors in Treasury, and then is announced and comes into effect whenever the minister says so.
I have no doubt that the minister's legal team went back to him on Wednesday morning, the day after our court case, and said it looks as if it is going to be inevitable that the 0.5% VAT increase that takes effect on the 1st of May could well be set aside by the court. And in that context, it seemed better for the minister to concede before he was perceived to have been forced to by the outcome of the DA's court challenge. And that is what has clearly happened in the last week. Now, it's also crucial from the DA's perspective that we set out these circumstances, because there's no doubt that the minister, in trying to save face, will seek to present this as the result of his discussions with the smaller parties.
Firstly, the EFF alleged at page 07/24 from paragraph 110 of the founding affidavit expressly that the rights that will be impacted are the rights to substantive equality, particularly of the poor, that stand to be hit the hardest by the unlawful VAT hike. Section 9. Section 10, paragraph 1102. Section 25, paragraph 1103. Section 27, paragraph 1110 and 1105. Section 29. But for my purposes, it's enough to stick to one right, which is the equality right. What the committee itself found, you will see at page 02/128, at paragraph 6.23.3, and this is the conclusion of the committee. I think Mr. Bishop said something about this being a recording of the submissions. No, it's actually a conclusion of the committee. That's how they assessed the evidence in front of them. They said, and you see this at 628, where they say the committee notes that the proposal to increase VAT by 0.5 percentage points in 2025 and 2026, which will take the VAT rate to 16%. The committee further notes the following, so that's their finding. 6.283. that increasing VAT would have a disproportionate adverse effect on the lower and middle income households, exacerbate inequality and the cost of living due to its regressive nature. And later on at 6.286, they say the following, that most stakeholders, however, have strongly opposed the VAT increase, particularly in the context of the ongoing cost of living crisis. That's actually a gross understatement. What had happened is that there were 48 submissions. Only 2 supported the VAT increase. It was PEP and PricewaterhouseCoopers. Every other submission rejected it. So you have a scenario in which the public participation process and the VAT increase is opposed by more than 98%. In fact, it then becomes a farce. The whole participation process becomes totally farcical. So when they say most stakeholders, what should have been here is that about 98% said no. 6.287, they say the following. The committee therefore acknowledges that while the VAT increase contributes significantly to the revenue framework, it raises serious equity concerns and must be carefully monitored for its impact on low-income households. There is a need for ongoing assessment of mitigation measures and transparency regarding the revenue raised and how it supports inclusive expenditure priorities. I will say that there was no such inclusion. They noted the problem, that there are equity concerns, that there should be mitigation measures, but there were no such mitigation measures.
Doesn't this issue not go to the question of ambiguity or the fact that the conclusion reached or the conclusion reflected on the report is not supported by the narration of the committee and what the committee actually debates and finds in its report?
Look, my lady, if I may say, this is an excellent point. It addresses I had seen it as an equality point, but it's also a rationality point. And then the solution, if one recalls, that was proposed by the minister was to zero rate certain items. But that is expressly rejected by the committee at 6.30, where the committee says, the committee notes the National Treasury's position on zero rating is a blunt instrument, as poor households still pay VAT on non-zero rated products and services. The committee recommends that the National Treasury should consider the recommendations made by the stakeholders on the list of zero rated items, which include an establishment of an independent expert panel to evaluate. So they did not find that the zero rating is sufficient protection for the inequality problems that the increase would exacerbate. And then at 6.31, as the committee notes the decision to not adjust PIT brackets for inflation, generating 19.5 billion in additional revenue. And then look at what happens next. The committee is concerned about the impact on lower and middle income households and recommends that National Treasury assess the equity implications of the fiscal ban and explore alternative progressive tax measures. And at 6.33 on the same page, the committee recommends that National Treasury and SARS should reconsider these proposals and engage further with the stakeholders to assess the viability of selected alternatives, especially where proposals are supported by credible empirical evidence. So I've taken 6 parts of the report where the committee itself acknowledges expressly that the 0.5% will exacerbate inequality. And this is in a country which already on the Gini coefficient is the most unequal in the world. Now, none of these were actually considered, these concerns, when the decision was made. The mitigation measures that were mentioned were simply not brought into operation. So it's therefore clear on the facts that the 0.5% percentage increase is a regressive measure. It exacerbates inequality. It is therefore in breach of Section 9 of the Constitution. You would therefore expect to find a substantive justification in the answering papers. The problem is that the answering affidavit of Parliament avoids the topic altogether. In fact, it says this is not the issue. It's not clear how they could have come to that conclusion in the light of the EFF intervention that squarely raises the problem. And then you think, well, maybe the minister will give a substantive justification based on the equality concerns. But you also find that the minister does not, in fact, justify the 0.5% other than by saying we need additional revenue to cover a number of other government spending requirements.
Does it not say to ameliorate that we're going to increase the number of goods that are zero rated?
Yes, but that's already been rejected by the committee itself, because it said the zero rating is a blunt instrument because the poor still have to pay for the other goods that are not zero rated. In any event, there is no zero rating right now because it is yet to happen through this independent panel that is yet to zero rating. So at the time the decision is made, there is no evidence of what is the impact of zero rating on the poor.
So by the 1st of May, there will be no zero rating to speak of.
There will be no change in zero rating. But the poor must pay the percentage increase.
Well, in fact, there's no panel yet.
There's no panel at all. So that zero rating, as Parliament said, is a blunt instrument. It doesn't take us anywhere. So we have a scenario in which there is a clear violation of constitutional rights. The two organs of state that are responsible for budgeting have forgotten their constitutional obligations to the poor. And we don't have to succeed on a final basis. This is a case that depends on the prima facie right. So we say that is sufficient.
The minister says he's short of 28 billion rands on his budget. That's why he's increasing the VAT. But VAT will not give him 28 billion. It will give him 13.5 billion. So he'll still be short. But you are saying to him, actually, you don't even need that. One, you need to tax the rich. The corporate tax was at some point 29%. It was dropped down to 27%. We're asking him, take it up back to 29%. It's not true that these companies are not making money. They are making money. The issue is illicit financial flows. It's underreporting of the profits, and. We've now given more money to SARS. So SARS should be able to go and get that money. By the way, SARS says that 800 billion rands that is out there that they can collect. So even if SARS was to get just 10% of that, that will solve the minister's problem. So the problem is not that there are no other avenues. The problem is the minister is scared to touch the rich. That's one point. The second point is introduce wealth tax. There's a lot of trust that's sitting with luxury properties that are not being taxed. But they use those portfolios to go and ask for loans in the banks. It's allowed. And by the way, the banks knows those portfolios. So they are known by the bank, those portfolios, because the banks are now able to use those properties to lend money to these owners. They have not been taxed. 3, there's apartheid inheritance. Introduce apartheid tax of everybody who inherited wealth in this country during apartheid, when you know what happened to our people. That will give you far much more money than the 28 billion you're looking for. But what the easy target is the poor. I mean, currently we can't afford to put bread on the table. Imagine with the 0.5 VAT increase, our people will literally die of poverty. This triple operation of poverty, inequality, unemployment is just going to be worse and worse off. So that is our plea to the minister. They did not listen to us in the committee. They even went to unprocedurally adopt the report, illegally so. We wrote to the speaker to bring the matter to her attention to say, this has been done in a wrong way.
Then the fiscal framework as it was what was the fiscal framework.
There was no intention to even look at those recommendations. I mean, the speaker was alert. The committee secretary was alerted to the problem the same day. The EFF sent a letter to the speaker the same day, the DA the next day, to say, look, we've got problems with this report, and it was pushed through to Parliament. There was no intention to engage with the 30 days. So at least on the face of it appears that Action SA naively thought that its strict condition was going to get even the most basic time of day. It was never anybody's intention. The purpose, which was simply to force it through. And if you look at the record, the minister, the chairperson of when Mr. Molefe says it's 7:47, what are we adopting? Because the report has changed so many times and we haven't seen the report. The chair says, let's proceed. and he wants an adoption. Then when the letters, the same day when the political parties contact the secretary of the committees and say this doesn't reflect what we've discussed, the letters are then sent to the speaker. It's literally pushed through. And what's quite extraordinary is that it didn't have to be. It could have, you could have, the process, the speaker, your client, could have slowed the whole process down and said, let's make sure we're all on board. We've got a report. This is an issue of national importance to every single person in the country. Let's make sure we're not seen as pushing this through with undue haste, and that we've dealt with all of the concerns that have been raised. But that was not the approach taken. In fact, it was the contrary approach. And one has to ask why. Why is there such a reluctance to engage either with the strict condition or to have the minister consider other options? Why is this no taxation without representation consideration just given short shrift?
Melanie, I can't say anything beyond the fact that the Action SA proposal, as it was sent to Parliament, is what was incorporated into the report. If the court is to find ultimately the report read as a whole doesn't meet the clear statement envisaged by 8.4 of the Money Bills Act, then I have to accept that that's the end of it in relation to those reports.
I think my sister raised an important issue also, that if not all members are on board, meaning not everyone understands what is being voted on at that point, that, and then it simply is adopted, does that not taint the process?
So, Melanie, that's a particularly difficult issue in relation to politics. And I say that cautiously because if the court is to listen to that record, it's clearly a large part of it is around political posturing overall. And it does raise the question as to what is the appropriate threshold, the appropriate point at which a chairperson can say, I've formulated the correct question, I've asked it, I've put it to the vote. The committee has spoken and I'm carrying that. And I would submit, and certainly
that is one way of looking at it. There's also another way. In particular, if you have regard to all the questions that have been asked by the MKP, Mr. Brian Molefe, Mr. Burke, then it's Mr. Van Rooyen of the MKP again, then Mr. Molefe again. The timestamp here that I've got on the record is 0947, paragraph 114.12. Mr. Molefe said that Mr. Beasley had stated as part of his motion that Action SA did not support VAT and asked whether that was part of what we have just adopted. So there was massive confusion. But why did the chair, as my learned sister has indicated, so adamant and eager to adopt this? For what possible reason?
Justices, I can't take it beyond referring the court to what I've said already.
When the Democratic Alliance entered the government of national unity, we made it very clear that our fight is not to dilute ourselves and become backups of the ANC. We did not suddenly wake up to have spaghetti spinal cords where anything and everything that the ANC says we go and we support because we are scared of the busts of the day. We came into the government of national unity with spinal cords of steel, clear that ours is to rescue South Africa, rescuing South Africa from decisions that are not in their best interests. A VAT increase has never been in the best interests of South Africans, whether it was 2%, whether it is 0.5%, or whether it was 0.00097%. The bottom line here is that the people of the Republic of South Africa made it clear to its government that they do not have money to pay more for food, that they do not have more money to pay for school shoes, for baby formula, for nappies, and essentially waking up and breathing in the morning. And that is a fight that we took upon ourselves as the Democratic Alliance. And alongside South Africans, we can together say this is our victory. Nobody else but South Africans and the Democratic Alliance can take this victory. We never lied to you. We never voted in favor of a framework that wanted to have a VAT hike. At no point were we April Fooled simply into rubber stamping decisions of the ANC. We have always been consistent, and today we are celebrating a victory of that hard work that the Democratic Alliance has been able to champion for South Africans. So I want to say again, reiterate, as Mama Zille said, thank you, South Africa. Thank you for your mandate to become your vanguards, and we commit moving forward that the Democratic Alliance will continue to become the voice of the voiceless. Ours is the constitution of this republic. Democracy is something that we take seriously. Your views, your hopes, your aspirations is our mandate, and in line with that, we will continue to fight.